Okay, good morning and welcome to Mo Notes featuring me, Monica Mo Justice. Okay, um, I decided this morning after much unwanted discussion last night that I'm going to segue into um, Breonna Taylor's um, uh, the Breonna Taylor situation from a different aspect. I'm going to come in on a fact introduction point because it's not going to change the hostility of the conversation as usual here. But I feel as if I need to approach things differently in order to drive conversation and have conversation. And the first thing that we need to do is first establish some background, right? When they make a law, they define stuff. So we need to define some things before we start to dive into no knock warrant. Um, and this is going to be specific to Joy's chit chat because for some reason she's very emotional about these no knock warrant um, things, right? And I don't know why it is, right? Um, and we begin with her questioning, that's my cousin, questioning um, a murder that took place, a homicide that took place in Chicago or Detroit, one of those cities where a no knock warrant was issued and a grandmother was in her house and the granddaughter was shot and killed when the police executed their no knock warrant looking for somebody, right? So we need to first explore the Fourth Amendment, what it means, what unreasonable search and seizure means as it was laid out in the Constitution, as it's laid out in our law, and where we arrive at the no knock warrant. We got that's Joy's personal case that she came and she compared the no knock warrant situation with Breonna Taylor. I'm not saying that it is a right comparison or a wrong comparison. I'm saying that that's where her passion comes in with this no knock warrant. And so I decided I'm going to take on that from the perspective of let's start to talk from ground zero before we get to the issue. Okay. So I'm gonna come to you with two articles today, and hopefully one I haven't read. The one from the Wall Street Journal, I just like the title, so I haven't read the concept. I haven't read deep inside of it. I put it on my reading list, and I never got back to it because I just think it. I'm just not that into the Breonna Taylor case. Okay, I'm sorry that I'm not that into it, and it's for its own reasons that probably start with this. And it doesn't mean that I won't cover it here, but I have to first believe that it 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 has injustice attached to it that we could benefit from in having healthy discussion. Okay, so let me pull this out so that I could hold up. Wait a minute. Ah, damn it. Hold on. I gotta find. Hey Diane, I got to find my YouTube channel to pull out the chat. The reason why I gotta pull out the chat is because y'all chat and I don't want to miss what's being stated in the chat. Shout out to the 4 new subscribers I received last night. Thank you for subscribing to my channel. I appreciate it, especially when the topic that you subscribed on has to do with some here and now stuff. Please hit the like button, which you guys have done already. Um, so moving on, because I just want to chat. I want the chat in real time. That's basically what I'm saying. So here is the article that I'm going to read, and here is the chat. And I don't got all money because I got to go to work. Okay, article, chat. Okay. When Monica, can you direct me to your video that you covered on reparations? Gracias. What made you think I covered a video on reparations? So see, people with their own figures coming in here talking about Fourth Amendment. We're talking about reparations. I'll do it at the end of this. The right of people, executions of warrants. The right of the people to be secure in their person. Oh, I know what I want to do. Yeah, I didn't write out a course lesson this morning. Okay, I just wanted to make sure that that's what that was coming from, Steve. All right, so here's what the Fourth Amendment states. It says, the right of the people to be secure in their person, houses, papers, papers alludes to documents, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons or things to be seized. Let me take a moment for y'all to zoom in on what thank you, Darren. What is the Fourth Amendment? The right of a person to be secured in their person. The right of the people to be secured in their persons, their houses, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon. So you can get an warrant. But here's the conditions of the warrant: probable cause, supported by an oath of affirmation. An oath of affirmation means that you're swearing under oath that you have probable cause. And you have to describe the place to be searched and the persons or things to be seized. Okay, so with that, execution of warrants. The Fourth Amendment generally touchstones on reasonableness. Everything in the law, I contend, touchstones on reasonableness, reasonableness. Okay, but here it says the Fourth Amendment's general touchstone of reasonableness governs the method of execution of the warrant. Until recently, however, most such issues have been dealt with by statute and rule. It was a rule at common law. So those of you that don't know what common law was, before we got statutes and structured law, we had common law, which these were just the things that commonly happened and they were the law. Nobody had it written down. It was just like common sense type shit. That was common law. And it got usurped by law being written that expired common law, that usurped common law. And then there are some places where common law, where things of common law still reign supreme. Okay, so it was a rule of common law that before an officer could break and enter, he must give notice of his office. authority, and purpose, and must in effect be refused admitted. Do you hear what this is saying? An officer has to, so let me break this down, has to seek permission first to do some stuff. And if you refuse it, guess what? He can't do it. That's why you hear the officer, can I, do you consent to a sobriety test? No, there's nothing he could do. Says right here, it was a rule of common law that before an officer could break and enter, he must give notice of his office, authority, and purpose, and must in effect be refused admittance. And until recently, this has been a statutory requirement in the federal system and generally in the states in the states. So this has been how stuff happens on the Fed side as a requirement, and this is how it generally happens in the states. Okay. In Kerr versus California, the court considered the rule of announcement as a constitutional requirement, although a majority there found circumstances justifying entry without announcement, aka no knock. That's when you don't announce yourself. Say, I'm a police officer. State what your purpose is. I'm here to execute a warrant. You see, which is common law that this is what they do on the federal side and generally what they do on the state side in your localities, right? In Wilson versus Arkansas, the court determined that the common law knock and announce rule is an element of the Fourth Amendment reasonableness inquiry. The rule is merely a presumption, however, that yields under various circumstances. So that yields. So knock and announce, it yields. Do you know what yield means for those of you who don't drive drunk? Yield means you pull up, you don't have to make a complete stop, but you yield to the other person. You yield to the person with the right of way. Even though you can go, you don't go forward because you let the other stuff happen. Yield. So, however, that yields under various circumstances, including those posing a threat of physical violence to officers, those in which a prisoner has escaped and taken refuge in his dwelling, and those in which officers have reason to believe that destruction of evidence is likely. So, what does that mean? If you're dealing in drug cases and you announce, knock, knock, who is it? Police officer Monica. I'm here with a warrant. Flush. There go the drugs. There go all the legal shit that's inside the house. Right? So this is the purpose of a no knock. Boom. Hi, I'm police officer. There's the element of surprise there. That's what most of these no knock warrants were envisioned for, to my knowledge. Okay, the test. So, in everything in law, there's a test that can be applied. So, here we go. The test, articulated 2 years later in Richards versus Wisconsin, is whether police have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime. In Richards, so if they knock, will it impact negatively on their investigation? Means that it won't allow them to get the information they need or to fully carry out whatever they were there to carry out. Like it doesn't make any sense that Tatiana Jefferson, that the officers didn't announce themselves while they was in the yard. If they had announced themselves, right, she wouldn't have had to reach for her gun to figure out who was in the yard and get killed by the officers in return. If they had announced themselves, there was no reason to be going on a wellness check and not announce yourself. Oh, they were under the impression that maybe the person inside was injured, but they was just walking around scavenging the side of the property. And we seen that on video. So we got that on video. So we all could process what happened there. And guess what? We processed it, and most people don't even talk about it to this day because we're on to the next big thing. It hasn't been forgotten, but just most people don't talk about it. Okay. So in Richards versus Wisconsin is whether the police have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of the crime. In Richards, the court held that there is no blanket exception to the rule. Whenever officers are executing a search warrant in a felony drug investigation, instead, a case by case analysis is required to determine whether no knock entry is justified under the circumstances. So the court held that there's no blanket exception to the rule. Whenever officers are executing a search warrant in a felony drug investigation, they have to do a case by case analysis to see if it's required to they have to do a case by case analysis is required to determine whether no knock entry is justified under the circumstances. So this is not just blanket. You can't just go out here and say we're going to do no knocks, no announcements. You have to justify why you're not announcing yourself. Similarly, if officers choose to knock and announce before searching for drugs, circumstances may justify forced entry if there is not a prompt response. So understand that. If an Officer Monica, I'm here, I have a warrant to search your premises. Crickets. Boom. I could pass in there. You don't have to give me, because one could say your delay was because you could potentially be destroying evidence. Do you see what kind of cases these are? Specific to drug cases, right? Just not blanket, no knock warrants. Specific to drug investigation. Similarly, if officers choose to knock and announce before searching for drugs, circumstances may justify forced entry if there is not a prompt response. Recent federal laws providing for the issuance of warrants authorizing in certain circumstances no knock entries to execute warrants will no doubt present the court with opportunities to explore the configurations of the rule of announcement. A statute regulating the expiration of a warrant and issuance of another should be liberally construed in favor of the individual. not individual. Similarly, just as the existence of probable cause must be established by fresh facts, so the execution of the warrant should be done in timely fashion so as to ensure, so far as possible, the continued existence of probable cause. So here's the question that comes in my mind when I hear the Breonna Taylor story or the issue that happened in Breonna Taylor is, when was the warrant obtained? So when is a date certain? When did they obtain the warrant and when did they execute the warrant? Those are questions I have. Now, if somebody got a date when they obtained the warrant, and then somebody got a date when they executed the warrant. So obtain is mean went into court and asked for the warrant. Went into the house and killed Breonna Taylor. Was it the same day? Was there days between? Those are very important and critical questions because we know that subsequent stuff happened, right? Not consequently, subsequent stuff happened. The man that the warrant was for was already in custody. So that's the first tier of the story that doesn't make any sense. If you already have a man in custody, how can you request a warrant for that man's arrest when you already have him? That's one of the biggest factors in the story. So, or in the events, in the incident, because it's not a story, it's an incident. I'm going to stop trying to get off of my ghettoisms and get into the reality of stuff. It's an event, it's an incident that occurred. So we need the facts, date certain. Because police actions and executions of warrants must be related to the objectives of the authorized intrusion. So, what does the warrant say they were there to do? As our understanding of what the Fourth Amendment said you must do. You must, and particularly describing the place to be searched and the person or things to be seized. So seize is you're going to arrest the person. So that's seizing a person. Or you're going to take things out of somebody's home. What are those things? What did the warrant say it was? Okay. And because privacy of the home lies at the core of the Fourth Amendment, police officers violate the amendment by bringing members of the media or other third parties into a home during execution of a warrant if presence of those persons was not in aid of execution of the warrant. So that's just to say, bad boys, what you gonna do? What you gonna do when I come for you? That's like having a media crew there when you execute in warrants. I don't know, So it's kind of telling us. I'm not even gonna go into assuming that stuff is staged, but in executing a warrant for a search of premises and of named persons on the premises. So you executing a warrant for a search of a premise, right? Premises. And of named persons on the premises. Police officers may not automatically search someone else found on the premises. If they can articulate some reasonable basis for fearing for their safety, they may conduct a pat down of the person. But in order to search, they must have probable cause particularized with respect to that person. However, in Michigan versus Summers, the court held that the officers arriving to execute a warrant for a search of a house could detain without being required to articulate any reasonable basis and necessary, therefore, without probable cause, the owner or occupant of the house, whom they encountered on the front porch leaving the premises. Okay, so somebody was walking off and they took him, even though he was no longer in the premises, he was leaving the premises. They affixed the search warrant to him. Um, the courts determined that such a detention, which was substantially less intrusive than an arrest, was justified because of the law enforcement interest in minimizing the risk of harm to officers, facilitating entry and conduct of the search. So here this person is outside when they're outside on the porch when they want to execute their search warrant, so they had to detain him so they can execute their search warrant without there being any interruption. The court determined that such a detention, which is substantially less intrusive than an arrest, was justified. Okay, for the same reasons, officers may use reasonable force, including handcuffs, to effectuate a detention. Do you see? I wanted to highlight this word, reasonable force, to start to bring in the image. Just close your eyes and just imagine the videos that you see, and you seen the officers handcuffing someone, and they using reasonable force in that detention of the person. Because it may be expected or within reason that there would be a struggle. Who wants to be detained? So they use handcuffs to detain. Because you can't just say, hey, get in the police car with me, and think that the person is just going to get in the police car with you and that's going to be all right. See how they didn't detain or use reasonable force when they were talking to Mr. Brooks, and how that went bad? They could have at any point, if they felt threatened by him, had put in handcuffs on him, used reasonable force. Also, under such circumstances, officers may search premises on the mistaken but reasonable belief. So they can search a premises with on the mistaken but reasonable belief that the premises are described in an otherwise valid warrant. Protection. Because the key words there are reasonable belief. This is where we come to the point that I continue to introduce. I come to conclusions based on information I had at that time. My decisions are factored based on that information. When the information changes, my decisions may change. Although for purposes of execution, okay, limits on detention incident to a search were addressed in Bailey versus the United States, a case in which an occupant exited his residence and traveled some distance before being stopped and detained. The Bailey court held that the detention was not constitutionally sustainable under the rule announced in Summers. According to the court, application of the categorical exception to probable cause requirements for detention incident to a search is determined by spatial proximity, meaning he wasn't in the area anymore. You can't go down the block and arrest somebody 10 miles away. That is whether the occupant is found within the immediate vicinity of the premises to be searched, and not by temporal proximity. That is, whether the occupant is detained as soon as reasonably practical. Hopefully that makes sense to people. If not, increase your vocabulary, get a dictionary, go to the thing and purchase a dictionary. Even on the side streets, they have dollar dictionaries where words can be explained. Okay. In so holding, the court reasoned that limiting the summons rule to the area within which an occupant poses a real threat ensures that the scope of the rule regarding detention incident to a search is confined to its underlying justification. That means we are here right now in front of here, and this is where all the information needs to be gathered from, not going down the block and detaining people 10 miles away. Although, for the purposes of execution, as for many other matters, there is little difference between search warrants and arrest warrants. One notable difference is that the possession of a valid arrest warrant cannot authorize authorities to enter the home of a third party looking for the person named in the warrant. Hear that? Let it rip inside your head. Let me repeat it because some people like to hear my voice. There is little difference between search warrants and arrest warrants. But one notable difference is that the possession of a valid arrest warrant cannot authorize authorities to enter the home of a third party looking for the person named in the warrant. In order to do that, they need a search warrant signifying that a magistrate has determined that there is probable cause to believe the person named is on the premises. I'm going to do this one more time for the Brianna case. One more time. Because the search warrant, in my understanding of the events in the Breonna Taylor case, was not for Breonna Taylor. It was for somebody else. So let me go through this sentence again one more time for the people in the lounge who just finished coughing their coffee up, burnt their tongue on the teeth. Although for purpose of execution, as for many other matters, there is little difference between search warrants and arrest warrants. One notable difference is that the possession of a valid arrest warrant cannot authorize authorities to enter the home of a third party looking for the person named in the warrant. In order to do that, they need a search warrant signifying that a magistrate has determined that there is probable cause to believe the person named is on the premises. Okay, so are we clear on that? All right. I heard you loud and clear. She said, I heard you loud and clear. All right, let me find the second article. That's given now. I've given a foundation in the Fourth Amendment. What the Constitution says and how people have interpreted what the Fourth Amendment means. as we take a deeper dive into the Brianna situation. I'm looking for this other screen to see. Okay, because I'm seeing one thing but doing another thing. Okay, so that's that. Let me find the other article. It's on one of these. It's on one of these tabs. And it's the article I'm looking for is coming from the Washington Post. I definitely have it on my phone. Let me just type in Washington Post. On this in this world, I swear. Oh, let me see. I think I saved it, but here it is. So the title of this article from the Washington Post says, "The no-knock warrant for Breonna Taylor was illegal. Police departments continue to violate an important Supreme Court ruling, and judges keep letting them." So here's what the article says. Just after midnight on March 13th, police in Louisville on a drug raid forced their way into the home of Breonna Taylor, a 26-year-old black woman who worked as an emergency room technician. Taylor's boyfriend, Kevin Walker, a licensed gun owner, woke up and grabbed his gun. According to the police, Walker then fired at them, and the police returned with a storm of at least 20 bullets, striking Taylor at least 8 times, killing her. One police officer was shot in the leg and is suspected to make full recovery. Walker was arrested and charged with attempted murder of a police officer. Those charges have since been dismissed. He says the police beat on the door for 30 to 45 seconds without identifying themselves. He thought he and Taylor were being attacked by criminals. According to Taylor's attorney, there were plainclothes officers, not a trained SWAT team. The Louisville police didn't find any drugs. We now know that Taylor wasn't even the person police were investigating. Their main purpose, their main suspect, Glover, because I don't know how to pronounce his first name, Jamar Creasy. Your mother anticipated you was going to be somebody important one day. You got a name like Jamar Creasy. And his accomplices were already in custody by the time the police raided Taylor's home. In the affidavit for the no-knock warrant for Taylor's home, a detective claimed to have consulted with a postal inspector who confirmed that Glover had been receiving packages at Taylor's address. But the Louisville postal inspector has since said that he was never consulted by the officers and that there was nothing suspicious about the packages. A source with knowledge of the case has since told me that the packages contain clothes and shoes. Most of this has been previously reported. Here is what has yet to be reported. The no-knock warrant for Breonna Taylor's home was illegal. In 1995, case Wilson v. Arkansas, The court recognized for the first time that the castle doctrine and the knock and announce rule are embedded in the Fourth Amendment. The castle doctrine, which dates back centuries to English common law, states that the home should be a place of peace and sanctuary. Accordingly, except for the most extreme circumstances, the police must not announce themselves and give time for the occupants of the home to answer the door peacefully and avoid the potential violence and destruction of a forced entry. The Wilson ruling did allow for some exceptions, though. Most notably, if the police can show that knocking and announcing would allow a particular suspect to dispose of evidence, flee, or assault the officers serving the warrant, the police can enter without knocking. After Wilson, many police departments exploited that exigent circumstances exception by simply declaring in search warrant affidavits that all drug dealers are a threat to dispose of evidence, flee, or assault the officers at the door. So in 1997, the Supreme Court unanimously ruled in Richards v. Wisconsin that this sort of blanket exception to the rule is unconstitutional. Here's a relevant excerpt from the court's opinion written by Justice Paul Stevens. If a per se expectation were allowed for each category of criminal investigation that included a considerable, albeit hypothetical, risk of danger to officers or destruction of evidence, the knock and announce element of the Fourth Amendment's reasonableness requirement would be meaningless. Thus, the fact that felony drug investigations may frequently present circumstances warranting a no knock entry cannot remove from the neutral scrutiny of a reviewing court the reasonableness of a police decision not to knock and announce in a particular case. Instead, in each case, it is the duty of the court confronted with the question to determine whether the facts and circumstances of the particular entry justify dispensing with the knock and announce requirement. In order to justify a no knock entry, the police must have a reasonable suspicion that knocking and announcing their presence under the particular circumstances would be dangerous or futile, or that it would inhibit the effective investigation of a crime, for example, allowing the destruction of evidence. In other words, the police must show why each individual suspect may be a threat to dispose of evidence, flee, or attack the police. They can't simply state that all drug suspects present such a threat. As Stevens points out, and Stevens is the judge here, the Supreme Court judge, the burden for the police here isn't high. They just have to provide something. The warrant for Taylor's home doesn't clear even the relatively low hurdle. In the portion asking for permission for a no knock entry, Detective Joshua James writes, affiance is requesting. So this is, remember we read the Fourth Amendment, and it says in the Fourth Amendment that there are parts to getting to getting the warrant. You have to have probable cause, and you have to have an oath of affirmation. Affirmation is affiant here. So this is his affirmation. Affiant is requesting a no-knock entry to the premises due to the nature of how these drug traffickers operate. The drug traffickers have a history of attempting to destroy evidence, have cameras on the location that compromise detectives once an approach to the dwelling is made, and have history of fleeing from law enforcement. Okay, so the Washington Post is quoting something, and then they state in their article the Louisville Police Department did not return a request for comment. So that means that they are writing this in writing, and they reached out to the police department, asked the police department to confirm what they are putting here, and the police department did not respond. So that protects the media outlet if the information is incorrect down the line. They can say, well, we asked them for comment and they provided none. Okay. The police actually obtained 5 warrants in connection with their investigation into Glover and his alleged associates. James, which is the police officer, requested no knock entry for all 5 warrants. And in all 5, he used the same language as above, almost word for word. This, by definition, is not particular to the circumstances. Yet, Louisville Circuit Judge Mary Shaw signed all 5 warrants. Louisville police um, could try to argue that by using the words these, James is stating that this particular group of suspects presents a risk for all of the threats he lists, but he provides little specific information as to why the targets represent a threat. The closest he comes is listing the prior criminal records of Glover and the other suspects. There's no evidence included of previously resisting police or committing violence against another person, nor is there any specific information about surveillance cameras at any of the residents rated. So Brianna had no criminal record except for a shoplifting charge in 2012 that was later dismissed. She had no history of violence or resisting police. There was no surveillance cameras at her house. Her only connection to the investigation is that Glover once received a package at her house, and Glover likely used her address because they had dated several years before and remained in touch. But James provided no specific reason for the police to think Taylor was a threat to dispose of evidence, assault the officers serving the warrant, or fleeing. Louisville police could also argue that the no knock provision in the Taylor warrant isn't relevant because the police claim to have repeatedly knocked and announced themselves before forcing their way inside. That was their first lie, as I understand it. Yet, according to Taylor's attorneys, 16 people in the densely populated neighborhood around Taylor say they heard the gunshots but never heard the police announce themselves. Taylor lived in an apartment building, so if the cops had announced loud enough to wake Taylor and Walker, one would think at least one of the neighbors would have heard it. Furthermore, Walker actually called 911 after the raid, telling the dispatcher, I don't know what happened. Somebody kicked in the door and shot my girlfriend. Pause. Wakes to sounds. He got to make a lot of phone calls. According to the mother's account of what happened, Breonna Taylor's mother, she received a phone call from Walker also that morning. So just imagine this. Police come inside your house, boom, 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 break in your door, right? Whichever side of the story you want to believe at this point, because there's no video image because the officers were not wearing body cams, right? Come into your home, start you Walker starts shooting, they respond shooting, right? Walker picks up the phone and calls 911. And he says, I don't know what happened. Somebody, he doesn't say the police, right? This gives you the knowledge, right? If the police had announced themselves, he would have said, the police kicked in the door and shot my girlfriend. He said somebody kicked in the door. So think about this series of events right now. In the timeline, boom, somebody comes in. You start shooting. They shoot back, shoot your girlfriend. You pick up 911 and call. You had time to call 911 to say, somebody kicked in the door and shot my girlfriend. It's unlikely that a man with no criminal record would knowingly shoot at police officers, then call 911 and pretend ignorant. It seems safe to say that if the police did announce themselves, Walker didn't hear it. I would agree with that. And that makes the raid legally indistinguishable from a no knock. Often in the raids, the police attempt to satisfy the knock and announce requirement by lightly announcing themselves and knocking either moments before or simultaneously as the battering ram hits the door. Police officers have admitted as much. In fact, police officers in Louisville have admitted as much. In a 2015 study, criminologist Brian Schaefer accompanied police on 73 raids. Now, remember what they said about having people along that are not there to help facilitate the raids. I'm just saying, facilitate the warrant. But this criminologist accompanied police on 73 raids in a city he called Bourbonville. Sam Oger, a attorney for Taylor's family, has since confirmed that the city in the study is Louisville. Of the 73 search warrants entries observed, every entry involved using a ram to break the door down. Further, the detectives announced their presence and purpose in conjunction with the first hit on the door. In conjunction with the first hit on the door. So they get over the loophole by announcing themselves, but it's during the time that they're ramming the door with the object. So the person on the other side of the door is only hearing the object because it's being overshadowed by the noise of the object and not the wording of the officers. So basically, this is saying the officers could have announced themselves, but under these circumstances, was it reasonable that the person on the other side of the door heard it? Is this reasonable behavior to act in this way or engage in an arrest in this way? A detective explained, as long as we announce our presence, we are good. I'm just speaking ahead of the article, sorry. We don't want to give them any time to destroy evidence or grab a weapon. Obviously, Mr. Walker grabbed his weapon. So we go fast and get through the door quick. Schaefer adds that in the raids he observed, the difference between how police served a no knock warrant and a knock and announce warrant was minimal in practice. Ironically, or perhaps not, the exception to the pattern was when the police were raiding someone they actually knew to be dangerous. Schaefer quotes a detective telling his raid team in one such case, "We need to actually announce our presence this time." I know that gun was probably under his pillow. He just went. Louise, in the in the real world, people do that now. People that are not supposed to have guns sleep with it at arm's reach. Louisville Police Department isn't the only one violating the Richards ruling. In 2018, I reviewed more than 105 no-knock warrants served by the police department in Little Rock. We're in Arkansas. Now we know that there's an Arkansas case because before we got into this article, we examined what? The Fourth Amendment. Okay, so in 97 of those warrants, the police provided no specific evidence about why the suspect met one of the exigent circumstances needed to dispense with the knock and announce requirement. Yet judges signed those warrants anyway. What are you talking about? Time out. You like to be correct. So I will say the S is silent. Good morning, Nicola. What are you talking about? I'm just going to pause here because I know she's busy. So I want her to be able to say what it is so I can see what she means before I go on. Oh, Louisville. That's how you say it, Louisville. I don't, all right. I don't know how to say it. I don't care. In Louisville. All right. So you pronounce it Louisville. Is that the consensus that it's pronounced Louisville? Let's go to the thing. Any other time you click on some shit and it goes right to how to say something. This motherfucker want to have music and shit. Let's go here.
Well, it's not Louis. It's not Louis. You have to almost swallow the word. Louisville.
Louisville. Okay, so it is pronounced Louisville. Okay, sounding like Louisville. All right, so now we all know how to say it. Louisville, 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 Louisville. Okay, so let's go back. Louisville Police Department isn't the only one violating the Richards ruling. In 2018, I reviewed more than 105 no knock warrants served by the police department in Little Rock. In 97 of those warrants, the police provided no specific evidence about the suspect met one of the extra why the suspect met one of the exigent circumstances needed to dispense with the knock and announce requirement. Yet judges signed those warrants anyway. Louisville. Okay. And even more egregious example in 2015, let me just say that. This is a happy Monday to you, Diane. This is a fine example of being corrected in real time and learning from the correction. Louisville. Okay. A South Carolina drug team raided, so this is in 2015, in South Carolina. Uh, a South Carolina drug team raided the home of Julian Baton, Baton, a 31-year-old black man, over a couple of low level marijuana sales. After battering down Benton's door, the officers shot him 9 times. Every officer on the task force claimed that members of the raid team knocked and announced multiple times before battering down the door. But footage from Benton's security camera showed they were lying. Lying. In depositions for Benton's lawsuit, one task force member testified wrongly. It's not the law to knock and announce. You know, it's just another. It just it you know it's just not. Another said that even when the drug unit wasn't given a no knock warrant, they almost always forcibly entered with knocking and announcing or simultaneously with announcing. So let me just repeat that. Another said that even when the drug unit wasn't given a no knock warrant, they almost always forcibly entered without knocking and announcing as simultaneously with announcing. So what's happening? Why are police departments blatantly violating a Supreme Court ruling? The answer lies in Supreme Court um, ruling subsequent to Richards, which is Hudson versus Michigan in 2006. In Hudson, the court ruled 5-4 that even if the police violate the knock and announce rule, the exclusionary rule is not applicable. The police can still use any incriminating evidence they find inside. The exclusionary rule is meant to be a deterrent to prevent police from violating the Fourth Amendment. But in his majority opinion, Justice Scalia argued that the rule was too extreme a remedy in these cases. Instead, Scalia argued that there are other ways to keep cops accountable. He referred to wide ranging reforms in U.S. policing, citing a criminologist who later wrote that Scalia had completely misinterpreted his work. More to come in my Supreme Court series. Scalia also pointed out that police officers who violate the rule can be sued, but police are protected from such lawsuits by the doctrine of I'll wait. We've been talking about it on this channel. Now I can't wait because I got to go to work. Qualified immunity, which makes it nearly impossible to collect damages, especially in cases where there's little established law. In my years covering this issue, I've never come across anyone who has ever won a lawsuit against police officers solely for violating the knock and announce rule. As for the new professionalism as of today, not a single police officer in Little Rock has been held accountable for illegal no knock warrants. One of the judges who signed off on a large portion of those warrants is currently running for higher judicial office. The detectives who requested many of those warrants, who was caught lying in one, and for whom there evidence that he lied in others, is still in charge of the city's drug investigation. See the theme here? All these no knock warrants appear on face value to be related to drug cases. I've yet to read anything that is to the contrary. There also has been no discipline of any kind for the officers um, who crippled Julian Benson. So this man didn't die when he got shot 9 times and they bust through his house. When the commander of the drug unit was asked in a deposition why none of the officers had been disciplined, he replied, "They didn't do anything wrong." Hudson was an enormously uh, consequential ruling. The knock and announce rule isn't a mere formality. At its heart is the notion that if the police are going to violate the safety and sanct- sanctity of the home, they should be forced to provide ample justification for doing so. That means a thorough investigation, plenty of surveillance, and double checking to verify their information to ensure that the suspect is a real threat and that they have the correct address. After the court's ruling in Hudson, those of us who worried about these taxes warned that without any real deterrent, police, judges, and prosecutors would eventually ignore the knock and announce rule entirely. Police would get sloppier with their warrants. They'll do less surveillance, investigation, and verification, and they'd be less vigilant about the rights of the people in the homes they storm. All of that would mean that more people, both cops and civilians, would die. That's exactly what has happened. Breonna Taylor's death wasn't some unimaginable accident, nor were the deaths of the people who have since died in similar ways. Her death was the entirely foreseeable consequence of a police department feeling free to callously and carelessly ignore the Fourth Amendment and the Supreme Court's decision to prioritize the integrity of drug prosecutions over the Fourth Amendment right of Americans to feel free, to feel safe and secure in their homes. Unless this is corrected, the next Breonna Taylor is coming. This is the article, again, out of the Washington Post. Now, it's easy to end it with fear mongering, but Breonna Taylor is our case in 2020. In 2021, 2019, we had the case that was out of Texas. I don't see enough. Let me just take this one moment to look for this one thing, and if I don't find it now, and if any of you have it, please forward it to me for use at another in another live regarding Breonna Taylor. I'm looking for the actual warrant. I want to see the language to close off this conversation. If anybody finds the actual warrant that was issued. Now remember the guy's name was, what was the boyfriend's name? Uh I need the guy's name because the warrant is not going. I don't believe the warrant is going to be in Brianna's name. I'm just looking for the warrant. That's all I'm looking for. I don't want to do no more stories on what happened. All right, here's some. I don't want to do no more stories, and then this is what this says. In his affidavit, James describes substantial. Okay, when he applied for a warrant to search Taylor's apartment, James also asked for four other warrants. One for the suspected trap house, allegedly are occupied by Jamar Crease Clover and Adrian Walker, no relations to Kenneth Walker, who was um, Breonna Taylor's boyfriend. Okay, at 2424 Elliott Avenue, two for vacant homes near the address, and one for the suspected stash house on West Muhammad Ali Boulevard. Today's notes that Jefferson County Circuit Judge Mary approved all five warrants within 12 minutes. In his affidavit, okay, so let's see if we find the affidavit. Describes substantial evidence that Glover and Adrian Walker were selling drugs. He noted pending drug charges against both men. His observation of 15 to 20 vehicles going to and from the house at 2424 Elliott Avenue within a short period of time. Surveillance camera footage showing Glover dropping and concealing a large blue cylinder shaped object next to rocks near the address. Video of both suspects going back and forth between the stash and the house. A December 30 search that found narcotics and firearms in the house, and a January 2nd traffic stop for speeding that discovered a small amount of marijuana and a large undetermined amount of U.S. currency located in the center console of a red 2017 Dodge Charger. Let me see this. Louisville. 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 Okay, but he was already in custody. We're not. I'm not there in my discussion. I'm not there with him being in custody. I'm asking for, so follow along with me. We know what has been revealed. I want to see what the date of the warrant, when the date the warrant was being executed. Notice in this article, the article tells you that that Jefferson County Circuit Judge Mary Shaw approved all five warrants within 12 minutes. They emphasized that it was within 12 minutes. On what day? Very important questions. Well, at another time, yo folks, we can argue respectfully the different positions on the outcome of these warrants, of these investigations. Right now, I'm just looking into simple, basic facts to establish foundation. So right now, I went to begin the discussion here because we discussed justice here. To begin the discussion by looking at what is a no-knock warrant. Where does it derive from? And the language comes out of or is contrary to your Fourth Amendment right. So you don't have a right to a no-knock warrant. It's an exception to it. So that's what we discovered today is an exception. And where we go from here is I would like to see the no-knock warrant, the affidavit that was sworn out. So we can now discuss what they asked for, and then we can start to discuss what occurred. His name is Jamarquise Glover. I'm looking for that warrant. Here we go. Let me see what date this is from. So it says April 2nd, 2020. What was the date of Brianna's murder? Well, this paper is stamped, filed the clerk's office, Jefferson County, and it says April 2nd, 2020. That's when it's stamped. Execution this 13th day of March 2020. All right. Um, of all the women screaming her name and blaming black men for her death, you're the only person I've seen putting in real work on her behalf for justice. Thank you kindly. Thank you. Mo, the reason I still have faith because the chick's wild. I don't know what happened. I'm just, did you write and copy it? Oh, you used the word faith. You can't use the word faith. Nightbot gonna get you. I'm gonna have to take faith off of the list. Okay. But this is how I look at everything. Okay. This is definitely check email, not sure. If we look at you sent me an email. Thank you, Nicola. I know this stuff interests you. I think yeah, we on the same thing, girly. Now, all I need to do is go back to the date of her murder, the date that Breonna Taylor died, just so I'm looking at the date. So she died on March 13th, 2020. Okay. This af- affiant was signed on March 12th, 2020. So it was obtained at, let me see what time in the afternoon. All of this is important because all these facts now that he puts inside his request, his facts, that he puts all this information that he puts inside this affidavit, it's what's now being taken apart. So we're going to end the live here, and I'm going to resume the live from this point when I come back later because I have to go to work and I don't want to start digging in something and not being able to tell it. But he got this on the 12th day. It was signed by the judge at 12:37 p.m. And let's see what time Breonna Taylor. Fuck it, I'm just gonna have to be late for work. I just want to read what he wrote in this shit and understand that this is how many documents. Yes, so Nicola, yes, we're looking at the same thing. This is one. This is two. It looks like it's just two documents. One, two. So this is a cursory look. Three. I see three times signed by the judge. All right. So proof of a felon having this day been made before me by Detective Joshua, whatever his name is, James, a police officer of Louisville. Yeah. Okay. That there is probable cause and reasonable cause for the issuance of this search warrant as set out in the affidavit attached hereto and made a part hereof as if fully set forth herein. You are commanded to search the premises known as. So this one is for St. Anthony Garden. And then it has the address and it says number 4, which is in Jefferson County, Kentucky, and all surrounding curtilage. Okay. And more particularly described as follows. Okay, so this particular dwelling, which is on Springfield Drive, is described as a multiple family 2-story apartment complex that contains a beige vinyl siding, multi brick. All right, I'm gonna have to do some speeding through shit because I gotta go to work. Numbers 303 are in the back lettering. The specific apartment has a shielding glass door that opens to a small patio on the first floor of the complex. The specific apartment has a green door and a gold plated number 4 in the top center of the front door. The apartment complex is located in St. Anthony Garden. All right, so this warrant, the first part of it is for the search of premises. So St. Anthony's Garden is one premises. The second part of this warrant is a vehicle and or in vehicle or vehicles described. So they're going to search vehicles and they got license plate numbers and stuff for vehicles they're going to search. Okay, so see how the warrant is laid out. The first thing they're searching vehicles, they're searching an apartment. Number two, they searching a vehicle. Number three, they're searching persons. And they list persons. And the persons that they have that they're going to search, right, is the guy Jamarcrius. The other one is the Adrian person. And the last person is Brianna. So we know, I just got to write this down. So we know okay, so this is the search part of the warrant. This is the search part. Now, the next part of the warrant is the seizure part, what they get to seize. They get to seize and seize the following described personal property: marijuana, cocaine, heroin, meth, and all illegal narcotics or paraphernalia as described in violation, whatever. Any monies that are proceeds from drug trafficking, any safes that are used to store illegal narcotics or money, any weapons that may be used to protect illegal narcotics or money, any paperwork that may be a record of narcotics sales or that may indicate the transport, concealment, or sales of narcotics. Any paper that may be evidence of individuals living in the residence. Any document to include mail matter which may indicate financial activities stemming from illegal activity. Any electronic recording media, computers, software, cameras, or any such devices that may be used to hold or document illegal narcotics activities in violation of KRS, whatever it is. Any item that may be evidence or other violations of Kentucky revised statutes. I thought that was for you. Oh, yeah. Oh, okay. I gotta put that up in my elephant collection. Okay. Um, if you find the above description property or any part thereof, you will seize the property and deliver it forthwith to me or any other court in which the offense is in respect to which the property or things taken is tribal. Is that? It's kind of funky. Or retain it in your custody subject to order of said court. Okay. So searching said premises, vehicle, person, description, and by seizing the following. So let's see if there's anything else. All right. So that's one affidavit for search warrant. Let's look at the second affidavit for search warrant. It lists the same thing. It says offense. Well, I don't know if this is the second one. It said no. The first one is a search warrant. The first document is a search warrant. The second document is now the affidavit of the search warrant. So remember when we looked at the Constitution, I gotta put this on this other screen over here. Um, when we looked at the Constitution, and the Constitution says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath of affirmation, and particularly describing the place to be searched and the persons and things to be seized. Okay, I gotta be scrolling, Nicola. One, two, three, four. All right, I'm on page 4. Okay, you want me to go to page 5 as the description? Let me see. Page 4 is the affidavit for search warrant. It's by the same officer. It's for the same St. Anthony's Gardens apartment. Number 4, it lists the same description as above and talking about which apartment it is. It talks about the vehicles again. It says that on any particular that they're going to search these premises and or in a vehicle described as, and they go back to that 2017 Dodge Charger. And here is where they state why they want the warrant. So on January 2nd, let me see, Nicola. I think this is what I'll come back with. I want to read what he did before I get in here. Let me see if I could do a search for. No, you can't. But I am going to download this. Hold on a second. Because girlfriend does want this document. Oh, which case is this? Mo Justice. This is going to be Brianna Taylor. I got to make a whole folder for her. I got to come back and read this because I want to see where her name is in it. And I can't just see her name. What they're supposed to get from her other than search her property. Ah, fuck it. We already here. On January 2nd, 2020, the police officer had LMPD tech units place a pole camera at the intersection of South 24th Street and Elliott Avenue. Within an hour of surveillance, the police officer um, witnessed approximately 15 to 20 vehicles go to and from 2424 Elliott Avenue within a short period of time, which is indicative of trafficking in narcotics. Okay, what's missing from here is he doesn't specify. He saw the people go to apartment number what? 4. On January 2nd, 2020, detectives observed Adrian O. Walker In operation of the above listed red Dodge Charger go to and from 2424 Elliott Avenue for a short period of time. Mr. Walker drove, I don't give a fuck where he drove. Detectives could smell, all right, he drove westbound on Elliott Avenue at a high rate of speed to which the traffic stop was conducted shortly after. Detectives could smell a strong odor of marijuana coming from the listed vehicle. A small amount of marijuana was located inside the vehicle, along with a large undetermined amount of U.S. currency located in the center console of the listed vehicle. Adrian Walker has a pending court case um, for COMP, convicted felon in possession of a firearm, drug paraphernalia, trafficking in marijuana, first offense, convicted felon in possession of trafficking in a controlled substance. So apparently they must have levels of how many times you could do shit in their state. Okay, so on January 8th, so let's understand this. On January 2nd, they put up this camera at 2424 Elliott Avenue. They observed all of these vehicles coming and going, and that made them believe that there was trafficking of narcotics because they saw vehicles come and go in a short period of time. One of the vehicles that they observed was Mr. Walker's driving erratically. So they stopped him, and this is what they found in his car. And then this is his history. So on January 8th, 2020, at approximately 13:36, so that's at 1:36 p.m., detectives observed Jamarcus Glover operating the above listed red 2017 Dodge Charger with Adrian Walker as a passenger. Detectives observed on the pole camera Jamarcus Glover exit the vehicle, walk over to the property line in 2425 and 2427 Elliott Avenue. Near there is a chain link fence that ends with an amount of large rocks appearing to be disturbed. Jamarcus Glover is seen on a zoomed camera dropping a large blue cylinder shaped object near the rocks and then appears to be covering up to avoid detection. Jamar, whatever the fuck his name is, Marquise, Jamarquise Glover, so Mr. Glover from now on, has a following pending court cases. Okay, he's got a whole bunch of shit with him, right? Notice this is in the warrant. Affiant, which is the police officer requesting this, has conducted surveillance multiple times on site near the physical location of 2424 Elliott Avenue and through the pole camera. The police officer has witnessed on occasion subjects running from 2424 Elliott Avenue to the rock pile near the property line of 2425 and 2427 Elliott Avenue, where Glover dropped the suspected narcotics, and then the subjects then ran back into 2424 Elliott Avenue. The police officer believes through his 10 years of narcotics related detective work and experience that Glover and Walker are the sources of narcotics for the trap house where the drugs are sold at 2424 Elliott Avenue. When the narcotics being dealt from 2424 are low Pedestrian and vehicular traffic is minimal. Mr. Walker and or Mr. Glover show up operating the red 2017 Dodge Charger and appear to re-up here the drug house at 2424 Elliott Avenue. Okay, we know that Elliott Avenue has now been described as an apartment building with multiple apartments in it. Why this affidavit doesn't specify an apartment as the trap house is killing me. But whatever. Mr. Walker, that's why I gotta read this again. But Mr. Walker and or Mr. Glover are seen either entering, exiting 2424 Elliott Avenue or going to drop suspected narcotics at the rock pile near the property line. 2425 and 2427 Elliott Avenue. Once they leave the area, normal pedestrian and vehicular traffic resumes. Okay, the police officer has observed the listed 2017 Dodge Charger make frequent trips from 2424 Elliott Avenue to 3003 Springfield Drive. Both Mr. Glover and Mr. Walker have been known to operate the listed vehicle. On January 16, 2020, during the afternoon hours, the police officer observed Glover operating the listed red 2017 Dodge Charger. Mr. Glover pulled up and parked in front of 3003 Springfield Drive. The officer then observed Glover walk directly into apartment 4 after a short period of time. Okay, so now I think I understand this. Apartment 4 is at 303 Springfield Drive. Let me go back up here to this girl. All right. That's apartment 4. Okay. So the trap house is in fact something. All right. So the trap house is not an apartment number. I stand corrected. The trap house is the address. The address of the trap house is 2424 Elliott Avenue. And they hide the drugs outside of the trap house at listen, drug addicts, just sit in your vehicle like the police officers and watch where your drug sellers go to. Find their stash and take their shit and get high. Advice. I'm just saying. At this point in time, it's easy to figure out what they was doing based on this shit right here. Okay, so let's go back to that the officer has observed the listed Dodge Traveler make frequent trips from 2424 Elliott Avenue to 303 Springfield Drive. Both Mr. Glover and Mr. Walker have been known to operate the listed vehicle. Okay. On January 16th, during the morning hours, the uh, police officer observed Mr. Glover operating the 2017 Dodge Charger. Mr. Glover pulled up and parked in front of 3003 Springfield Drive. Affiliate then observed Mr. Glover walk directly into apartment number 4. After a short period of time, Mr. Glover was seen exiting the apartment with a suspected USPS package in his right hand. Mr. Glover then got into the red 2017 Dodge Charger and drove straight to 2605 West Muhammad Ali Boulevard, which is Oh, which is a known drug house. So we got a trap house, we got a drug house, we got a fucking address, and we got to think. All right, the police officer verified through a U.S. postal inspector. Notice, no postal inspector's name here, but whatever, that Glover has been receiving packages at 3003 Springfield Drive. He probably spoke to the fucking mail person and said to the mail person, did you deliver anything to Glover? Do you deliver to Glover here? And the mail person probably said yes. It probably wasn't no damn inspector. It was just a regular mail person. Because the mail people have the same route. Anyway, routes, however y'all want to say it. Okay, so the officer knows through training and experience that this is not uncommon for drug traffickers to receive mail packages at different locations to avoid detection from law enforcement. This seems like a whole bunch of assumptions in this shit. Where's your evidence that these people did this? The officers talk like you YouTube people. I'm just amazing. Okay, he verified. Oh God. So this is just his gut. It's basically what this man wrote in his affidavit. There's no anything to support his gut. He didn't intercept a package or see. It's not like the post office received the package and it accidentally tore and fell apart, and then you see inside the package that the person had some drugs inside of it or something in a package, and you say, "We believe that drugs is being shipped to this address because this is what we have." Okay, so far I don't see where the officer lied about anything. I just see where the officer assumed shit was happening. See the difference? He didn't say shit was happening. He said, I'm assuming this shit happened because this typically happens. Tomato, tomatoes. Okay. Okay. So this is based on his experience, right? But not based on any facts that that's what happened in this case. Okay, so the officer believes through training and experience that Mr. Glover may be keeping narcotics and or proceeds from the sale of narcotics in Brianna's apartment for safekeeping. Let me carry on. Officer has observed the above listed white 2016 Chevrolet Impala parked in front of 2424 Elliott Avenue on different occasions. This vehicle is registered to Breonna Taylor. Officer has verified through multiple computer databases that Breonna Taylor lives at. Officer verified through multiple computer databases that as of February 20th, Jamar Glover, something as his current home address. So he used her address as his current home address. I can't see because they redacted something in the document. Mr. Glover and Mr. Walker are acquaintances and have been seen going to and from 2424 Elliott Avenue. Additionally, the red 2017 Dodge Charger has been driven by these individuals mentioned within this affidavit. Officer has witnessed during physical surveillance the suspect drug traffickers sharing the 2017 Dodge Charger numerous times to transport and store their suspected narcotics. 2016 Chevrolet Impala, white in color, whatever, whatever, uh, thing. We're missing something. There's something missing here because it just goes into describing the white Impala. And they tell us in this other doc, they tell us in number 10 that the Impala belongs to Breonna Taylor. Okay, so we're gonna go down. They go to this car, then they go back to asking to uh, search Marquise uh, Walker and Taylor. What did I call this document? This is a search warrant. We still don't have no arrest warrants here. We just got search warrants. And we don't have any search warrant. Okay, let's go on. They're just searching said premises and vehicles and persons described here within. Okay, the affidavit believes and states there is probable and reasonable cause to believe said property uh, constitutes property or things used as means of committing a crime, property or things in possession of a person who intends to use it as a means of committing a crime, property or things in possession of a person whom it was delivered for the purposes of concealing it or preventing its discovery, and which is intended to be used as a means of committing a crime, and property or things consisting of evidence which tends to show a crime has been committed or a particular person has committed a crime. Okay, so the officer has been an officer in the aforementioned agency for a period of 15 years and he doesn't list the month. The information and observations contained herein are received and made in his or her capacity as an officer hereto. Now, if this was being completely filled in, completely accurate, I think he would list the months. You ever have to do an application that says how many years and months you lived at an address? You would say, "Oh, I moved in December, so now we're in January. I mean, we're in April. June." You would say, "I lived there 6 months. I've lived here a year and 6 months." Something like to that effect. So, kind of interesting. On March 12th, 2020, at approximately 10 a.m., the applicant received information from. So this is all the stuff he observed, right? This right here now is why he was seeking this order. All the other stuff that I've read is the history. He gave a backdrop as to what he's been observing or whatever. So here we go with the next part. On March 12th, which is the day before Brianna was murdered in her house by the officers, the police officer received information from multiple LMPD crime tips, most recent being 1/18/2020. tip number 27, whatever, whatever, that there has been drug activity going on at 2424 Elliott Avenue. A narcotics search warrant was executed by LMPD 1st Division on 12/30 2019, where narcotics and firearms were recovered. Okay. Less than a week after the search warrant, so I'm trying to follow the days, there was a search warrant issued um, December 30th for narcotics, and firearms were recovered. Then there was a tip that came on January 18th, because it says less than a week after the search warrant. All right, so less than a week would be anywhere between January 1st and January 2nd. Well, yeah, January 7th. And that's a little bit more than a week in that time frame, because December has 31 days. So it says less than a week after the search warrant, the police received information that the drug activity had resumed at 2424 Elliott Avenue. After conducted, so the police officer conducted physical surveillance and witnessed vehicle traffic. So that's when we go back to the top part of the thing, and he says on January 2nd. So listen what happened. They executed a search warrant on December 30th. That's why the days of January 2nd are very important, because that was less than a week later. That's when he put in the camera to start watching 2424. And that's when he observed these things, and that's when they pulled over Mr. Walker. See how this is starting to make sense? They conducted a physical surveillance and witnessed vehicle traffic going to and from the listed location for short periods of time, which is indicative of trafficking in narcotics. They go back to describing the Dodge, and they go back to describing the Impala. The only thing that I don't understand right now is this is based on activities, an arrest that were made in December, subsequent, or consequently, but subsequent to that, they put up video cameras and observed some stuff. And then a tip came in January 18th, but they requested this warrant on March 12th. What happened between January 18th and March 12th? Let me see. Is number 14 up there? Okay. So now he comes down here and we go to number 15 at the bottom of all of this. Affidavit is requesting a no knock. And listen, this is bullshit right here. You see how number 14 is up on page 5? So in right in court documents or whatever, you number each paragraph so you can keep consistent with the paragraphs, right? It's as if this language is standard in number 15, and they leave it for the end, whatever the last page of the document is going to be, and they stuck in this number 15. The officer is requesting a no knock entry to the premises. Doesn't list which premises they're asking for the no knock warrant for on this page. It just says to the premises. Doesn't say to the aforementioned premises. They have several premises listed here. To the premises, so premises, due to the nature of how these drug traffickers operate. These drug traffickers have a history of attempting to destroy evidence, have cameras on the location, that compromised detectives once an approach to the dwelling is made and have a history of fleeing from law enforcement. Then there's a big ass space in the middle of the page. Which way am I coming to y'all? Which platform am I using? I don't got time to figure out how to share the screen to show y'all. Y'all could go see this. Then it says the affiant has reasonable and probable cause to believe grounds exist for issuance of a search warrant based on the aforementioned facts, information, and circumstances, and praise a search warrant be issued, that the property be seized and brought before the court. I wonder if at some point we're gonna get to a place. See, we all watch Law and Order, and then I'm about to go. We all watch Law and Order, and when we watch Law and Order, we never saw the detectives go and execute a warrant without speaking to whom? I'm waiting for a response. The district attorney. So as we're looking at, no, they went to the judge. The judge signed off on this warrant, but there's an important person missing in this conversation. And Law and Order, the show on television, every time the detectives or the police officers encountered a situation, they went to the DA's office to have the DA request the warrant. Maybe that's a significant change that needs to be made in what we're doing. That's where reality may not be meeting the real world. That may be the fictitious part of what we see, because we've been watching Law and Order and we've seen that happen. So we automatically believe that these warrants have been vetted to the judge. So this sounds like I'm the police officer. I write out my shit for the warrant. I go and I present it to the judge. Maybe that conversation and maybe one of the reforms that we need to start addressing is not just eliminating the no knock warrant, but perfecting the methodology that they get the warrant in the first place, which means having somebody with a legal eye look at this shit before it's presented to the judge for a sign off. I don't know. I didn't know that a police officer, honestly, I guess I'll just watch Law and Order. I'm not a criminal, I'm not in criminal justice. I just always thought it was just like Law and Order. The police officers talk to the DA, and the DA presents it to the judge, and the judge signs off on it. It appears that these warrants are issued by just the police officer going before the judge, or the police officer presenting it maybe to his command captain or whatever, and then going before the judge. There's no in between. Hey, ICO, because I didn't see you come in. Bam, good morning. And Kels, good morning. I think that this was, I'm going to toot my own horn this morning. I think this was an in depth beginning into looking into Breonna Taylor's case, to see if it's worthy of me exploring it further on this channel. Now, I'm going to say this one more time because people seem a little confused about how shit works over here. This is my channel, and I get to pick which cases I'm going to follow or not follow, because it don't make sense for me to follow all the cases. I try to pick cases that are uh, controversial on two sides. So call me the two-faced justice person. I like to look at stuff from the perspective of the prosecutor, the person seeking the justice, or from the perspective of the victim, and or the perspective of the defendant. So I try to look at the cases from a 360 approach. Even though I formulated my own opinion on it, I do try to look at stuff from all the perspectives to help people come to their final conclusions. And at least if you pick a side, but some of you don't know how to pick a side, but at least if you pick a side, you could defend your side based on information and facts to help strengthen your position on your side. I don't do this looking for rights and wrong. I do this because I think there's confusion as to how law works. People come up here and they be acting like they all kinds of attorneys up on this motherfucker. They know everything. And they don't know a god darn thing. They just been they've just been given the gift for gab, and they do it all the time. Now, I'm going to say this to a comment that was inside the chat, and then I'm going to go. Do you see what I see inside of this search warrant? I see an enormous gap in information. The search warrant was submitted on March something based on information that was about 30 days old. So I'm wondering if part of the protocol is that they take these search warrants and submit them to the court, and when the court puts them on the calendar is when they go before the court with the information. So I would think on March 12th, when one goes before the court to seek this search warrant based on stuff that happened December 30th, January 1st, January 18th, and you asking for a search warrant on March 12th, there's no information here of anything new that happened between January 18th and March 12th. And that in and of itself may have contributed to why they didn't know the man was in custody, because this was not based on timely information as stated in the opinions of the court. I think it was in Richards versus Wisconsin, or what the Supreme Court has put in place to say you need to execute a warrant in a timely fashion. If I was a judge, I would not have signed off on something that talked and spoke on activities from December, January. And here we even skipped, there was a February date mentioned in here, I believe. Was it February 2nd? Something occurring on February 2nd. There's a January 16th date when he went to the address and picked up some mail. All this stuff happened in January. For all we know, Brianna could have been dating this dude because it sounded like he had a key to her apartment in January. Maybe he didn't have one in March. You ever messed around with somebody and they don't return your fucking key and you just ain't changed the lock? Because I can't see any chick having a relationship with a new guy that's sleeping in her bed with his whole Swiss and Wesson with him. He got his Nina on deck under your pillow, ready to shoot for your honor. And another Negro has the keys to your place, can come and go in your shit as he pleases. But you know, you people in the new year and age, y'all be doing all kinds of new shit. So maybe old dudes got access to your apartment. Yeah. Let me just help y'all because sometimes I don't think y'all know how to ration out the bank between y'all legs. Some women around here, right? If you are messing with a new dude, and the old dude got keys to your apartment and he could just come and go, but there's no indication that he had keys to her apartment because she could have been home on the day he came to pick up the package. The police officer's statement here, affidavit, doesn't give you any information as to how he entered. They just say he went into apartment 4. Doesn't say he knocked and waited to be received. It doesn't give us that specificity. But we just know that he went into apartment 4 on that day. He was there and he came out with a package. But that was in January. Homegirl got a new boyfriend in March. So obviously, some facts may have changed when this was executed. So it's easy to Monday morning quarterback these people in their actions, but it's more important to be like, and I'm still wondering why, if all of this took place in March, why this affidavit is filed in the court's office on April 2nd, 2020. When all of this stuff, yeah, nobody do that shit. I broke up with a Negro. He's not coming. I don't know. I gotta think about this. Can I have the new guy coming into my apartment and the old guy got sleeping in my bed with his Nina, and the new dude got keys to the Beamer, could just come inside my shit? The story of Breonna Taylor doesn't make sense to me. So this is the beginning of it. We will now begin to explore the next level of information that comes out from a legal perspective. I will not be doing what y'all heard, which I had heard on the street. I don't know. He pulled out on the police officer. Girl, you don't know. You don't know where your man got his piece. How he gonna protect you? It might just be under the bed. He might just have to reach down and buck off. I don't know. Guns are not legal in New York, so I can't speak on where dudes got guns that I know. Like I can't speak on that. I gotta plead the fifth around here. And that's it. Anyway, this is that shit I be on some days. That I be on some days. And that's it. I want to once again thank you guys for your time. Um, oh, that's what it is. I'm on StreamYard. See, I was trying to figure out where the fuck I was at today. If I knew this, I would have done this. Yeah, you know exactly where theirs at. So, I don't know. But I'm gonna tell you right now, shout out to Mr. Walker, because he held that shit down. He at least he bucked off at whoever came through the door. So I can't be mad at Mr. Walker. He held his ground. He stood his ground. He followed the castle doctrine down to the bone. Yeah, girl, let me just tell you what occurred today. I went through the Fourth Amendment. I introduced it. I will discuss it. We'll do it together in real time here. But I went through the Fourth Amendment and what the Fourth Amendment means. Why there's the emphasis right now on the no knock, uh, no knock warrants to give a baseline understanding of what is our constitutional right, yours, mine, and everybody's. Even three-fifths of a person, right about now, because people tend to want to keep going back in time with stuff. I'm here in the present. In the present, that's what the Fourth Amendment is about. And I reviewed the Fourth Amendment. I reviewed case law that supports the Fourth Amendment to give you the intent of the Fourth Amendment, how it's been defended in courts and how it's been presented in the court uh, for the past uh, couple of years, different cases that were associated with the Fourth Amendment. Then I brought you an article in the from the Washington Post that says that the no knock warrant in Breonna Taylor's situation was illegal from their perspective. And then I said, where's the warrant? So I'm starting from fact one. Where's the warrant that brought the police officers to the apartment? And that's how I'm going to dissect or take on Brianna's case as it stands, by the legal information available, not by news articles, not by commentary, not by interviews from family members and all that other stuff. I want to work with what is legally out there, because there's too much stuff that has been stated that I don't feel like going back and forth. This is why there was such a big argument last night in a simple situation of being drunk and people wanting to not take accountability for being drunk. You understand? I don't got time to be sitting up here arguing the frivolous things when at the end of the day we're arguing things that are not that important to me. And I don't know if it was emphasized enough. And for those I'm talking about the Wendy's shooting, right? That is a case of excessive force. There's no if, ands, or buts about it. It's excessive force. But it's not just because he shot the man in the back and all of those other things, and they could have let him walk home and they do this in the white neighborhoods. When people give me the argument, they do this in the white neighborhoods, I say, show me. Give me the cases of the white people that got to walk home from a traffic violence. I know so personally. Bring me your personal knowledge. You know why people argue those kind of positions? Because they think it's going to shut you up because they know more than you, allegedly. They don't know more than you. They are pissing on you and telling you that it's raining. They're not much more knowledgeable than you. They want to hold the upper hand of the conversation by doubting you. It is the same thing when we was dealing with COVID. I said black people are getting COVID. Oh, black people don't have that. Oh, black people don't have COVID. What was the first argument made? Do you know anybody with COVID? Since black people got it, I don't have to know nobody with COVID to see that black people got it. What ended up happening? Black people had it, and all those people that was up here on their high and mighty that black people can't get COVID, They disappeared in the argument and went on to something else. Some motherfuckers on here love to talk because nobody's talking to them in their real fucking lives. Life is lonely out there. So they come in here and they chat gangster, they gangster chat. Yeah, they thugging, bugging on their fingers, they gangster chatting in your chat room, and that's it. Some posture themselves and come on the platform on some other bullshit. But at the end of the day, that's what they do. That's how they sustain themselves. They're not they're not people of credibility. Their credibility has been wavered by everything else going on in their acts. Good morning, Nikkei. But that's what they do. That's exactly how they present themselves. When they can't gangster chat, then they be up inside the chat chatting while drinking. Just throwing shit out there randomly just to start conversations and shit. I'm going to remind folks, and I'm going to put up the video this week. If that's what you do in other rooms, great. You won't do that shit over here. That's not what this works like. I don't give a flying fuck how you operate in other people's rooms. That's not going to occur over here. I got standards. We uppity over here. We got expectations that are manageable. You can even call it, if you had a job, they call it smart goals. We got smart goals over here. They're measurable. The conversations are measurable. Any other places that you've been at, they got their own set of rules. Y'all reign supreme. I, Mo Justice, reign supreme here. And so, yes, I move differently, and you either move differently with me, or you could have a seat in the lounge. You can watch me on replay, because this is a different kind of structure. And I'm no longer going to sit up here and keep trying to defend my structure. If you violate my structure, bye, deuces. That's it. And it's not a sense of control. This is the environment that you're in. You don't run me, I run this. That's it. You go other places, you're able to run that shit and do the shit that y'all do over there. And when I'm over there, when in Rome, do like the Romans. In Mo, do like the Moans. In Motown, do like the influencers. Watch their lead. See how they interact. See how they converse. How the conversation moves forward. We're talking on the subject. We're talking to the subject, so that we're getting a broader understanding of people's positions or what they're presenting. I can easily zoom in on influencers' statements to see where I'm going wrong, what I need to harvest as a next discussion point. This not Dramaville. I'm not here promoting haphazard bullshit. I'm over here having serious conversations that I hope lead to something. This morning's discovery is that perhaps one of the police reforms should also involve the police having to obtain warrants via the DA's office when dealing with the police, when dealing with executing warrants. They should go through the DA's office so that those warrants could be better vetted. If you're asking a police officer to do 1,000,000 steps out on the road, right? Look at that sobriety test, right? Giving him 4 different levels of checking if he's drunk. Fuck if your nose smells he's drunk. You smell like you drunk. You look like you drunk. You're acting like you drunk. All right. So we had to have the man walk. We had to have the man follow his eyes. We had to have the man hop on one leg or whatever the fuck that was. And then we issued the test. With the police officer out in the street from that engagement is doing all the legal process so that the prosecutor could win their case in court. What does the prosecutor do? So it seems like roles have been reversed. He smelled like a drunk. He took the test and he was like a drunk. You have taken officers and now we put a camera on their body. We've made them into robots, basically. We're second guessing and undermining their thought process while they're out in the street. Whenever somebody is second in split second decisions, we are may now be jeopardizing their safety as officers because we're undermining their ability to perform. And with that, that's why you have officers calling out and talking, I ain't going to work today. They don't know what circumstances they're working on. But folks want to say it's systemic racism. Yes, it imploded on them. The system that they were working with has finally turned its nasty back on the developers of it, and it makes nobody safe. It's not safe for the police officers, and it's not safe for us in the community. Community policing or policing as we know it is not good. We're in a state of emergency because the people that we have hired and retained to serve and protect us can't. You cannot. If you go in to have a major procedure with the surgeon, would you, if you went to a consultation with a surgeon to have a heart surgery, so to speak, and the day before your heart surgery, you sit in with a consultation, a post of a pre-op consult, and the dude that's about to operate on your heart is sitting there the whole time like this with his hands shaking and shivering or whatever. Do you let that person operate on you? You'll be like, how long you had that little nervous condition with your damn hands? How does that work in the operating room? Like you would start thinking about that. That's what's happening with police officers now. We put the cameras on them, and personal judgment is out the window. They can only or should only be doing what textbook book doc, whatever the standard operating procedures are in place. They should be operating to that no matter what. We're taking discretion out of it, but at the same time, the community is saying you should have discretion. You should not be able to do this. You should be able to do that. This is why we have people micromanaging from the back seat. You can't work effectively under those conditions. And if you were in any other line of business and you had that much oversight, you would either conform to the oversight or leave. And eventually, that's what's going to happen. But you wouldn't have chased racism out of there because most of these racist people, and this may become factual, can't do nothing else in fucking life but be overseer type people. They don't have the ability to work beyond that. What the fuck they gonna do for a living? If they not a human running around with a gun inside their side holster, they not prepared to do anything else. That's all they thought they was gonna do. Now that's coming at risk. No, I'm not talking about surgeons having body cams. I'm talking about you having confidence. The purpose of talking about the surgeon right now is that you have to be confident that he can fulfill his responsibility to you. And in this situation, the confidence in the police department, when we talk about state of emergency, when you have a president signing an executive order to talk about revamping or whatever he called it with the police department, you have to really understand that to get to a point where you need an executive order, that something is astray. Something is astray. Something needs to be done differently. The confidence level in the police department has reached an all time low. People calling it tyranny. You've got people now resisting arrest and fighting back like hell on high waters. One last thing I want to clarify because it was in my last chat. Honey Lot. I sent her an email this morning because in my last chat, she sent me a picture of what is what has been reported on social media as a white officer burning down the auto zone. So I went back and I looked for arrests in the auto zone fires. And we're talking about the auto zone is in Minnesota. This is at the beginning of the Floyd protest. I've yet to find anything in my search, and if you should come upon it, please share it with me. Um, if uh, if well, if an NYPD police officer uh did a chokehold as of June 22nd, the governor of New York signed an order last week that said the chokeholds were banned in New York. I believe that's what I remember seeing, but I'll go check my facts on that. But I believe that's what he signed, no chokeholds in New York. Maybe I'm wrong, but I don't like to be wrong, so I'll have to check that. But anyway, in respect to Honey Lot, she put inside the chat that this man is a suspect. It's a police officer who did this. And I noticed that people were saying that videos got taken down. This is how YouTube operates. If you spread disinformation, fuck misinformation, okay? If you spread disinformation that YouTube can quote an authoritative source as saying otherwise, they will remove your video just on that basis because an authoritative source said otherwise. So then you have to be creative in the way in which you put things out. So I looked at the video that she sent me on Facebook. And to me, Facebook is not a credible sourcing for me. And I said that last night. So I had to take a second look at it us outside of the channel because I didn't have time to do that in the middle of what I was doing. But yes, I took a second look at it before I got up here this morning. And then I did my own slight due diligence and sent several articles to her where the police department verifies that the officer that people are accusing of being the fire starter, and I got to take that on two levels for the AutoZone building was in fact at work or here. So they're showing you video camera footage at the time that they say he's setting this place on fire, where he's someplace else. That is called for you smart asses an alibi. And if you have an alibi, even if somebody was to arrest him and say you look like this person in this situation, if you can present an alibi for it so you can have probable cause to arrest somebody, and then somebody can come and show you their alibi that negates your probable cause. So you can have probable cause. He looks like the person, he smells like the person, he seems like the person, he resembles the person. Okay, fine. So we arrest him thinking he is the person, and then he has concrete evidence that he's somewhere else. He couldn't possibly be the person. That's what they did in this case. So what I got in the chat was, it's a fact. No, it's not a fact. Today, there's no arrest. And here's what's even more egregious in that little clip there of the man at uh, the auto zone. The man at the auto zone, we don't have no video of that particular white man in all black setting the place on fire. What we have video of him doing is crashing out windows. They really not concerned who vandalized the joint as they are concerned with who set the bitch on fire. Do I go after the person that threw some rocks at a building, or do I want the person that burnt the building to a rubble? So even if that had been the officer that they arrested for them saying that he was that person, all they have that person doing is busting out windows. They don't got him setting the fire. Now, if you got pictures of him setting the fire, please send that to me because I didn't see that in any of the things that I'm saying. Him being the guy, all the white man, all inside this black stuff, looking and dressing similar to our missing chick who burnt down the Wendy's establishment. She was all in black, covering everything but just the facial eyes. Too strategic for it to be unintentional. That's all I'm saying. And I looked through tons of emails today, tons of articles where they're showing and have video of different people of interest that they're looking for in conjunction with burning shit. The Aldis, the Target. You understand? They're looking for these fire bombers. And as we know in New York, our own fire bombers, guess what they were? Attorneys by day, militant mofos by night. Okay. Two books that I am moving on to read, that I am reading now, if you want to join me on them. In the spirit of, and I still got to get that book, The New Jim Crow. I am reading a Huey P. Newton, not the fake ass Huey Newton we got up in here. Huey P. we got up in here. I am reading Revolutionary Suicide. I don't know nothing about the book. I didn't even read the introduction of the book. I picked up the book based on its title and who the author was. And I'm going to read that book in this day and age because I'm feeling kind of that way. And on the other flip side of it, these are my July picks because somebody asked me for it, and I think that's the way to go. My other July pick, uh, for those that don't want to be so militant, I went to, and they're in the car. I got to go back to the car to get the damn books out the car. Um, I have another book by her. It's Toni Morrison, The Bluest Eye, or something like that. Um, it was referenced many times when I read the book, The Bluest Eye. So I picked it up. God help the child. Because God help most of you. Somebody needs to help y'all. Yeah, Karen of Wendy's. They still looking for her, and it looks like they're still looking for a lot of people in a conjunction with setting these things. And I still wonder if there's any remorse in the Karen in Wendy's Karen. The reason why I'm saying that is because having seen how this stuff played out from day one to the last day, was it worth burning down the Wendy's? It is always unless gentrification is the objective, because I still remain at awe that in Minneapolis they allowed, yeah, well, I'm gonna read that book because I hadn't read the book, but it had many references in God bless the child. God help the child. And actually, the other day, in one sitting, I went back through God help the child from cover to cover just one day last week, just sitting around in the house. I just read it from cover to cover because it's easy to read a book a second time around quicker than the first time around, um, because of it. And the references to that other book were in there, and I was like, oh, I just wanna read it. And I think it's just thing. There's a whole, I didn't even know The Women of Brewster Place was a book when I know it's a movie. Um, so I'm probably gonna add that one to the list so you folks in the movie world could do the movie, and me, I could do the book and then do a compare and contrast to the movie as we did with The Color Purple, where we did a compare and contrast to the book The Color Purple versus its movie last year. And that's it. Okay, that's where I stand this morning. For those of you that joined later, please take a view back at the beginning when I discuss when I segue this topic in of Breonna Taylor. And I feel like as a woman of color, right? Um, the best way to respect the image of other women of color is telling their story from inception to the final, whatever the final statement is. And so that's why I entered at this point. It is my thought process. It doesn't make me wrong, it makes it right for me. If you disagree with it, you don't have to follow me along with it. But one thing I'm not going to do that y'all have done successfully as channel holders in the social space, y'all have broken down people's image so bad that we got to sweep up the pieces. And still, as we take the shards of the life that you leave behind us to look at, especially when we talk about women situations up in here, y'all break down the woman so badly that all the other women can do is just sit there and be like, oh, I'm not going to be a party to that. I've seen y'all do that too much. And y'all don't want to take accountability and break down the image of the man, even when he's wrong. For most part, when the women are wrong, she tends to be protecting you motherfucking men in her wrongness. She's doing something that furthers the man's position in shit, allowing a man to still use her address. But there's no indication that he was still using her address as of March, as he was in January. Maybe in January, when he got arrested, maybe she was like, "Yo, you involved in some shit. I'm living a different life. Thug bye." Maybe she cut him off. We don't know. But I will tell you that when you get legal representation, so this is for BAM, and your attorney tells you to do something, trust your attorney. Do the shit your attorney tells you to do. Why is Brianna's mother on the Breakfast Club? Where's her attorney? Isn't that helping the story like that? I would love to hear her part, but not from Angela Yee. It was disgusting. I didn't even finish listening because I think she was in the wrong place trying to get that out. I'm not interested in who burnt down AutoZone. The purpose of me referencing AutoZone this morning is that inside my chat yesterday, somebody presented to me that something was a fact. And I'm coming back and saying it's not a fact because this is the information that I was able to find less than 24 hours of you telling me it's a fact. I don't care who burned any of these facilities down. When I was concerned about people infiltrating the Black Lives Matter movement, most people weren't concerned. When I was concerned that young people were out there being infiltrated by these Karens, by I don't know what y'all calling the white males that are doing this stuff. You know what you people said to me? Whoever you people are, y'all said, oh, they out there. They could die for the revolution. Some people just gonna have to die for the cause. I didn't subscribe to that. I didn't believe in that. But that's what people was on here talking when I was saying, wait a second, we got the young people out here marching and people are infiltrating them with their own agendas, the shoplifters and everything. And the comments were, oh, you lose some inside the revolution. Oh fuck no. I want to call back the revolutionaries because they've been infiltrated not to have the I want the revolution to be able to live forward to the next day. Not being infiltrated by these bad actors. That was my level of concern. See, I worry about the people. When most people don't care about the people. They said, fuck it. It's a cause. The people gonna be in it. Some of them is gonna die. I had a man on my platform say that. I was like, oh, excuse me. You know, unfortunately, that's gonna happen. I had many of you write in my chat. That's what's gonna happen. Well, I disagree with that. If you know that people are being infiltrated, you need to call back in the army and say, hey, listen, we need to do this a different way. I was concerned about safety. I said, when I saw an attorney standing there with a medical examiner igniting the flames to get more people to be out there protesting by the information they were giving out. When I listened to protesters say they didn't even charge him with murder, and knowing that he got murder in the third degree as his first charge, I was like, draw that back. He's been charged with murder. Call it what it is. Don't call it what you don't want it to be. That's not true. She has an attorney. She has Ben Crump. She has an attorney. In the Brianna case, which I was referencing in respect to the mother being on the Breakfast Club and all this other stuff, Ben Crump is her attorney. She's retained them. She told us this. Oh, YouTube people. Well, I wasn't talking about YouTube people. I was talking about Ben Crump. I was talking about Brianna's mother when I was speaking on having an attorney. It was specific to that, not the people on the YouTube. The people on the YouTube have come here and they have said, when I have presented opposite this, who's out there in the protest world, But yesterday specifically, why the police officer came up as being was because we were talking about who's setting the shit on fire, who's burning the shit down. And they was like, it's police officers. It's, you can't say that without any facts to back it up. And then to say it's a fact, well, you're going to have to show me the fact. And please don't get mad because you can't present the facts to me. That's a problem on here. Whenever I tell people, well, evidence it. How did you get to that point? They don't want to shit it. I said it. I went and I looked. I know this. This guy. Well, pass me by with that bullshit. If you know it, show it. When I know something, I come back and I break it down and evidence it. Now, you don't have to go along with my evidence. That's fine. But I have the wherewithal and the knowledge of me to at least come back and say, this is where I got my opinion comes from this. Anyway, no, I know I was just making a correlation. Oh, I don't know. Right. That's how I know people on here who say they have an attorney don't. Because the first thing an attorney will say is no public speaking on the case. Oh, man, please. I'm going to tell you this. Even if you had went to a police department and you speak to a police officer, as I have done in circumstances, the police department will tell you, don't come on the internet speaking about it. It's an ongoing investigation. Keep your mouth shut. Anyway, this is Mo, and I've got to go. Thank you for your time and consideration. I truly appreciate it.